Well, folks, the deadline has officially passed for the Department of Justice to respond to the nationwide nullification of the ATF's highly controversial regulation that tried to classify brace pistols as if they were short-barreled rifles. And now we've got a major development. The Fifth Circuit Court of Appeals has formally put oral arguments on the calendar in the high-profile case over pistol braces. Like I said, right out of the gate, this is a serious turn in the ongoing legal battle over the ATF's attempt to reclassify millions of legally owned firearms outfitted with stabilizing braces. As things stand, there's still a nationwide freeze in place, preventing enforcement of the brace rule, along with several preliminary court orders that continue to shield manufacturers, firearm owners, and members of various pro-Second Amendment groups. But here's where it gets interesting. With the recent change in political leadership and a new executive order from President Trump that firmly reaffirms his administration's support for the Second Amendment, the Fifth Circuit hit pause on the Mock versus Garland lawsuit. That delay wasn't random. It was actually requested by the incoming administration. They asked the court for a bit more time to decide exactly how they wanted to handle the brace rule moving forward. The court agreed and granted a 30-day extension, which automatically ended on Monday, April 14th. By then, the Attorney General's office was supposed to file an official notice laying out what their next move would be. But here's the kicker. Nothing has shown up in the public docket so far. That radio silence didn't last forever, though. Just recently, the Fifth Circuit made a move. The court has now scheduled oral arguments for the week of August 4th, locking in the next step in this critical brace-related case. That action strongly implies that the judges either received communication from the Attorney General's team or simply decided to proceed without it, suggesting the current administration intends to carry on with the legal fight. If that's true, it's a bit unsettling. It could signal that the new leadership is not planning to walk back the ATF's stance on pistol braces after all. That's definitely not the direction many gun owners and supporters of the Trump-backed Second Amendment task force were hoping to see. Looks like this administration might still be fighting, just not on our side. Now, let's not forget the ATF hasn't had much luck defending this rule in court. They've already taken several serious hits. A number of courts handed down preliminary injunctions stopping enforcement, and the most notable blow came from Judge O'Connor, who delivered a final ruling in the Mock case. That decision didn't just slap the ATF on the wrist, it completely wiped the brace rule off the books across the country. In his final decision, Judge O'Connor pointed out that after reviewing the record, the court found the final rule functioned more like a law passed by Congress than an administrative regulation. He also noted that the finished version of the rule strayed too far from the original proposal, violating the legal framework required for rulemaking. Because of that, the entire thing was tossed out as unlawful or, at the very least, sent back to be properly rewritten through the legal process. That wasn't just a win on a technicality, it was a landmark decision. A full final judgment tossing the rule for good carries major weight. This wasn't a short-term stay, and it wasn't limited to a single district. It shut down the ATF's entire brace classification scheme as legally flawed and unconstitutional. Naturally, after suffering that defeat, the ATF wasted no time appealing the decision to the Fifth Circuit. At this point, all of the briefs have been filed, and the case is officially in the court's hands. It's worth pointing out that the original appeal was launched under the Biden administration, which strongly supported the brace rule and openly opposed Judge O'Connor's ruling. Now, oral arguments were expected to move forward until things shifted dramatically when the Trump administration took office. That's when the new White House team reached out to the Fifth Circuit, asking the court to temporarily pause the case while they took a fresh look at the ATF's brace rule and decided how to proceed. According to a formal submission from the Attorney General's office, dated February 7, 2025, President Trump signed an executive order titled Protecting Second Amendment Rights. This directive instructed the Attorney General to launch a sweeping review of all federal agency rules, to identify any actions that might undermine Americans' constitutional right to keep and bear arms. As part of that initiative, the AG was ordered to submit a detailed strategy through the Domestic Policy Council, laying out how the administration intends to defend and preserve Second Amendment protections moving forward. More specifically, that order required a thorough reassessment of every firearm-related rule or policy issued by both the Department of Justice and the Bureau of Alcohol, Tobacco, Firearms, and Explosives during the period between January of 2021 and January of 2025. That includes anything impacting gun owners, gun dealers, or the broader firearms industry. Based on that instruction, the AG's office respectfully asked the Fifth Circuit to put the pistol brace appeal on hold for 60 days. The reasoning? A delay would save the court and involve parties from wasting time or resources while the administration reviewed whether the rule itself was even legally sound. That move strongly hinted that the Trump White House might be considering a full reversal of the previous administration's position, a shift that could lead to abandoning the ATF's brace rule altogether. That would mark a major departure from the hardline stance we saw under President Biden. The court agreed and granted the requested 60-day pause. But now that time has expired, and so far, we've seen no formal update from the AG's office about what they plan to do next. No filings, no new legal strategy, nothing. In response, the Fifth Circuit has taken matters into its own hands and gone ahead with scheduling oral arguments. That hearing is now set to take place during the week of August 4th. That move suggests the court may have received informal word that the government intends to proceed with the case, possibly sticking to the original defense of the brace rule. If so, that's an unwelcome sign for gun owners who were hoping the new leadership would finally walk away from this flawed regulation. The fact that the case is moving forward has certainly caught the attention of Second Amendment advocates across the country. That said, there are still a few signs of encouragement. Recent internal communications from the AG's Chief of Staff show that the Department of Justice is actively reevaluating how it handles other high-profile gun rights cases. In the Peterson suppressor challenge, which is also being heard by the Fifth Circuit, the AG's office has announced it will be revising its stance. On top of that, the department has now pledged to launch investigations into California jurisdictions where concealed carry permits are being delayed or block, something that has long been a point of frustration for law-abiding gun owners out west. Those steps point in a direction that's more aligned with constitutional principles. But when it comes to this specific brace case, we're still in the dark. Until the administration takes a clear position, we can't assume they're ready to admit that the pistol brace rule was unconstitutional from the beginning. We can only hope they choose to back away and finally do what's right, acknowledge that this rule never should have existed in the first place. As of now, all signs indicate that the Fifth Circuit is gearing up to hear oral arguments during the week of August 4th. What's especially interesting is that no updated briefing schedule has appeared on the court's docket. Normally, if the administration planned to change direction or offer a new legal argument, the court would set new deadlines to reflect that. But so far, crickets. Meanwhile, there's an important development happening over on Capitol Hill. There's a major push underway to include the SHORT Act in the Senate's ongoing budget reconciliation package. If passed, this bill would remove short-barreled rifles and short-barreled shotguns from the National Firearms Act, entirely meaning they'd no longer be classified as NFA-regulated items. If that legislation clears Congress and President Trump signs it into law, it would effectively erase the whole pistol brace debate. The controversy would be over. Full stop. On top of that, the House of Representatives just passed the Hearing Protection Act, and it's now headed over to the Senate for consideration. If you're in favor of that bill or the SHORT Act, or both, now's the time to get off the sidelines and make your voice heard. I urge you to pick up the phone and contact your senators directly. You can reach them through the Capitol switchboard by dialing 202-224. 3121. When you get through, just ask to be connected to your senator's office and leave a short, clear message stating your support for both the Hearing Protection Act and the Short Act. Every call counts. Now, circling back to the court battle, here's a key detail to keep in mind. The current proceedings in the Fifth Circuit do not overturn the nationwide decision already handed down by Judge O'Connor. His final ruling, which invalidated the ATF's pistol brace regulation on the merits, is still in effect and remains the controlling law across the country for now. That nationwide vacatur stays in place unless the Fifth Circuit decides to reverse it on appeal, or unless the Trump administration takes separate action to amend or cancel the rule entirely. There's even a real chance the oral arguments, currently set for early August, could end up being unnecessary. If the administration and the ATF choose to resolve the issue outside the courtroom, this entire appeal could get shelved. We've already seen that happen with the forced reset trigger situation, where the case ended in a negotiated resolution rather than a final ruling. Personally, I have mixed feelings about how that one wrapped up, but it does show that some of these fights can be resolved behind the scenes. A similar compromise on the brace rule is definitely within the realm of possibility. And if that happens, the lawsuit could be dismissed entirely. But even if that doesn't come to pass, gun owners are still on solid ground. The legal arguments are strong, and if the Fifth Circuit ends up issuing a definitive ruling in our favor, that would be a major win, not just for this case, but for the long haul. A clear decision at the appellate level would set binding precedent that protects us from future overreach, especially if a less Second Amendment-friendly administration takes office down the line. And let's say, worst-case scenario, that we don't manage to get the Short Act passed through Congress. Having a strong pro-gun court ruling in this case becomes even more critical. It gives us long-term legal cover and strengthens our position for years to come. So that's the current snapshot of where things stand in the fight over the ATF's pistol brace rule. Right now, the rule is still null and void nationwide, thanks to the work done in Judge O'Connor's court. As we continue to get new information and clearer signals from the administration about their next steps, I'll make sure to keep you all updated. Thanks for watching and sticking with me through this deep dive. If you got value out of this update, please give the video a thumbs up, drop your thoughts down in the comments, and hit that subscribe button so you don't miss what's coming next. And remember, this country was built by thinkers who were armed, and it'll be safeguarded by citizens who stay alert, stay equipped, and stay free.